So welcome to land transactions workshop, and basically today we shall be looking through the highlights or what is expected from this workshop. Please don't forget to like, subscribe, share and comment, and please turn on that notification button because here we analyze all the workshops and we also give you tips which will help you to pass the oral exams. So if you want to get all analysis of both workshops from intake 1 and intake 2, and also tips to pass oral exams and also category B exams, then you can subscribe, like, share and comment. So basically we are going to be dealing with interest in land, and this model deals with rights in land, how they are acquired, protected, controlled, regulated, and in some cases how they may be lost. So basically we understand that Article 26 of the 1995 Constitution gives people right on land in Uganda. And we are very much aware that you can own land in Uganda under the 4 tenure systems. That is land, freehold, leasehold, as well as customary. So those are the tenure systems which are also recognized by the Constitution, as well as Section 2 read together with Section 3 of the Land Act. So learning outcomes, by the end of this workshop you should be able to explain the different interests in land in Uganda. So we are all aware that according to the case of Katarika versus Katwiremu, you can have legal as well as equitable interest. So if I have bought land and then registered it and have a certificate of title, then that means I have a legal interest. But if I also buy a land through a sales agreement, that means I have an equitable interest. So these interests were defined in the case of Katarika versus Katwiremu. If you want to understand more about interest in land, so it has the principle relating to acquisition of interest in land. How do we acquire land? So we shall look at different ways of acquiring land. Of course, one by you can be joint tenants, you can be tenants in common, and what's the difference between joint tenant and tenants in common? So if you want to get more distinction about that, you can go and look in section 56 of the LRTA, because it clearly defines who are joint tenants and who are tenants in common. Then structured transactions relating to acquisitions and preparation of interest in land. So we are going to draft a sales agreement. We shall be lodging caveats which all aim at protecting the interests in land. Recognize and deal with ESCO issues relating to acquisition and protection of interest in land. So basically when we talk about ESCO issues, we are talking about the Advocates Act as well as the Professional Code of Conduct regulations therein. So you shouldn't overcharge your clients, you should avoid conflict of interest, you should make sure that you pay all the appropriate fees. For example, stamp duty, we have case law that states that failure to pay stamp duty renders the transaction an illegality. So you should, I think that was the case of it was discussed in the case of Ben Kavya, something like that, where they talked about that you must pay stamp duty, and fail to pay stamp duty, then that means your transaction is an illegal transaction. Of course, I want to look at different authorities, the Constitution, the LRTA, and the Land Act. Then interest in land, we have already talked about interest in land. In Boyes versus Gasure, the court is stating that any person with an interest in land can lodge a caveat, and the interest can be equitable or it can be legal, like the way we discussed above. Then we shall also see the sale of legal and equitable interest in land, and have the case of Katariko versus Katwiremu, that you can sell legal interest, but once someone has paid you, for example, assume that there is a transaction and I have paid you to buy your land, I have deposited part of it. The case of Sharifa Osman versus Haruna Marangwa states that once I have made initial deposit, then I have an equitable interest. So that means basically that you cannot sell my land or your land to another buyer, because I own an equitable interest in that land. Therefore you are always entitled to the remaining balance, but you cannot get a better buyer and sell the land. Of course, we're going to look at that in workshop 2 when we get there. Need for due diligence in land transactions. You will be interested by the judgment in Sir John Bangeri versus Aosu Matovu, where the court stated that land is not vegetables, where you buy from unknown vendors. You should read that judgment. It has been reiterated in several cases as they need to do due diligence. The court is saying that no, land is not like vegetables where you go on the street and you just find the nice tomatoes you want and then you just buy and take home. No, for land, you have to do diligence to identify who are the owners of that land, and also you can take extra measures to see where they could have bought that land from. So basically, that's a locus classicus case as far as due diligence is concerned. Now, we shall also look at the importance of the certificate of title. Section 59 of the RTA is very clear and straightforward. The certificate of title is conclusive evidence of ownership. This has been reiterated in several cases, including Kampala Bottlers versus Dominico Uganda Limited. So we shall also look at tenants by occupants on land. Of course, we shall look at Section 29 of the Land Act, defining who are tenants by occupants. We shall look at lawful and bona fide occupant. Who is a lawful occupant? Once you have entered land with the consent of the registered proprietor, you become a lawful occupant. If you have been settled on that land by the government, you are a bona fide occupant. So you have to look at Section 29 of the Land Act, and also several cases have come in to define those different types of occupancy, including Justin Rotaya versus Starling Civil Company Limited. Then family land, of course, a lot of decisions we have in the Muyabazi versus Imperial Stephen, where the court is saying that any transaction on family land without spousal consent, then it's an illegality. Also, we have the case of Alice Okrur versus Global Capital Save, where there was a transaction, and then the court also came and stated that any land you do on family land without spousal consent, then it's always an illegal transaction. You cannot transact on family land without spousal consent. So that's the principle they are in. Then consents to deal. So when you want to buy land, you must acquire the necessary consents. It could be from joint tenants. It could be from spouses, all those consents, or maybe from other tenants. Then we shall look at adverse possession. Basically, adverse possession, as you can see in the case of Salim versus Boyed, and also Namburu Chintu versus Ephraim Kamuntu. If you have stayed on land for more than 12 years and challenged it, then you can proceed and apply in the RTA, and then you can be given certificate of titles. That's what we call adverse possession, if you have been on the land and challenged it for more than 12 years. So basically, that was the introduction. I was trying to take you through these cases. But in case you need more discussion on this workshop, please, we have a mastermind group where we discuss all these in details, and then immediately after the discussion, we issue very highly qualitative notes. And I will also do this on Saturday as well as on Sunday. And you get notes in time, and also a Saturday discussion, which is online. So that means in case you are in Mbale, in case you are in Lila, in case you are in Mbalala, and also here in Kampala, then you can be part of that team, and you get to meet these dedicated students who are committed in passing the bar. And of course, I tell you that you are going to pass the bar. So workshop 1. The workshop deals with the identification of different rights in land and the requisite steps. One undertakes to establish the viability of possible land. So learning outcomes explain the different interests in land in Uganda, illustrates the required due diligence on one undertakes to establish a viable land transaction, draft various documents one needs when establishing the viability of possible land transaction, for recognize and deal with ethical issues relating to the requisite steps, inquiries one undertakes to establish the viability of possible land transactions. So workshop facts. Assuming that you are a legal associate of PNA Associates located at Plot 10 Rumumba Avenue, Kampala, good luck or Emijisha. Your client is before you. He informs you that he wants to sell off all his properties, so as to invest his money in unit trusts. The particulars of the said properties as follows. Land complies in channel of block 200 plot number 152 Chanja, which is developed with a residential house in which Good Luck lives with his wife Rose and their 2 children aged 2 and 4 years respectively. So for you to advise on this particular land, you have to go and look on the titles and first identify which type of tenure system is this? Which type of tenure system is this? Is it Milo? And then after that, that's when you can be able to advise. So the titles were annexed. When you look on the titles, you will have to understand which type of tenure system we are dealing with. Then land comprised in freehold, 5 report Plot 2A, Guamaha Road, Kabanda, measuring 9 acres. Mr. Goodluck tells you that he was registered on the land in 2020 with a V instrument number. However, the land is exclusively occupied by Brian Musoke, 45-year-old woman who has a banana plantation on it. Mr. Goodluck tells you Mr. Brian Musoke purports that his father, late Stephen Musoke, was allowed to use the land by a 1/0 and that he fully inherited it from his late father, Severino Musoke. So basically you can see that here we are dealing with freehold, and this Odubuzei man becomes a lawful occupant because he came into that land with the consent of the lawful owner during that time. So that means he becomes a lawful occupant. Then we go to 2, land comprised in LLV. On this land there is a block of apartments fully occupied by tenants. So this is leasehold, and the leasehold is being occupied by tenants. We shall also look at that. So basically you have to also understand now, you have to go on those titles and then identify who are the owners of that land. Sometimes you find that this land is being owned by what? By a company, and the only way you can tell that is when you go on the certificate of titles which we are annexed. Then for a 3-acre place of land at Chanchima, Nango Bogayaza Wakiso, with a fruit garden and banana plantation on which his family relies for food and fruits invested every week. Goodluck Owamisha, a file identification card with Uganda Land Board. So basically here we can see that this is family land. So and we are very aware to the laws governing family land. You cannot deal with it when you don't have spousal consent. So basically we are going to look at these other titles and then we analyze them. Then the last land comprised in freehold west, measuring 70 acres with a banana plantation on it. Goodluck and his wife Rose are registered as joint tenants. So basically these are joint tenants, and we know that the laws governing joint tenants, that you cannot deal in land which is owned by joint tenants without the consent of the other tenant. So basically that's it for this introduction, but allow me to go and look on our titles so as I can give you a clear view of how do you read these titles, because it can also be an oral question. So please make sure that once you get those titles, you take time to understand how do you read titles, because in oral questions you can be put a certificate of title before you, and then you will be required to answer questions. So as far as the first property is concerned, Chanondo Brook 200, it's in Kampala, and we can see that from the ownership, it has been transferred. When you see that there are crosses on the ownership part, there are very many crosses. So that means those were the former owners, but they have since transferred it to Goodluck Owamisha, and it's under. When you look at it's under private Milo, it's property description of property. You can see that it's private Milo, so it's under private Milo, and it's owned by Goodluck Owamisha, whose NIN number is also attached, and is the only one. We can see there is a deed plan. A deed plan is just made by surveyors, who gives you if in case you want to open boundaries, and then that's what happens. So that was the first title. Then when you go to the second title, freehold at Rwamhanda, Kabanda. When you go to the second title, Kabanda, description of land. The second title, description of land. This one is under hectares, Kasanga, proprietorship, Goodluck Owamisha, name and address. Then RTA. So the leasehold is hereby attached. So when it's owned under leasehold, there is also what we call a lease agreement. So this one, the second title is the one for Kansanga. This second title is the one for for Kansanga. Yeah, the second title is one for Kansanga, as we can see from here, and we have the lease agreement attached. So you have to basically look at the lease agreement and you see whether the years are still running, and you see whether the years are still running, the premium, and also how many years are left. Then we go to the second title. When I look at the second title, from the annexures, these annexures we are shared. Together with our workshop. So please endeavor to look at them, because it can be your oral question. It can be put before you, and then you are being asked to identify whether there are any covenants or conditions on that particular title, or maybe to advise your client on whether he can buy that land and carry out farming. So the second title is about the one in Bugahaya, and the one in Bugahaya is Block Plot 401, Block 20 at Chinongozi West. It's the last property. Promise Omisha is owned by Promise Omisha and Good Luck Omisha as joint tenants. Yes, we looked at this one where they are joint tenants, and under section 56, that means they must transact as a whole. It's supported by deed plan. Deed plan is just made by surveyors, and after the deed plan, we have restriction of the user restricted farming and housing. So that means you cannot buy it for industrialization. So I think that was it. That's how I can analyze these titles. But there is a title I think I have not seen, land comprised in Chando or Block 200. Let me see whether I can trace that title very quickly from these annexures which we are shared. Land comprised in Chandondo, Block 200. When you go back to our titles, here it's supposed to be the first title. So basically what you do is you have to go back to these titles and basically want to see ownership part. Yes, it was the first one. That one, it was the first one. Then the second one was about Ruamahua Road in Kabanda. Let me also see whether I can trace that title. So basically when you're going to certificate of titles, you want to see the ownership. The ownership is the part that gives you, basically owns that land. Then from there, you want to see description of the land, and there you are looking at who is under which mile tenure and the hectares. Then also you want to look at the proprietorship part as well as the covenants and conditions. So basically that's how I can introduce these certificate of titles. I think we are good to go. We can now continue to our next task. But please endeavor to read these titles because anytime they can be they can be your oral question. So when you go to tasks, advise the clients on the following: the pertinent aspects about the land as discerned from the facts and the certificate of titles presented to you. So basically when you're doing this, you have to go at each type of title and then give advice. For example, when we're talking about the one owned by joint tenants, you cannot deal with it when you have not contacted or obtained consent from the second joint tenant. And this one is under section 56 of the RTA. When you're talking about the property on family land, we have a lot of decisions. Also, versus Global Capital Save in the Mperirwe. Both of them are saying that you cannot make any transaction on the land when you don't have spousal consent. Also, the one for tenants, you have to obtain consent, or you have to give notice to this consent before you proceed to buy this building. So basically, that's how we look at pertinent aspects of these different titles. You look at the description of the property, you look at ownership, and if there are any other conditions or covenants. All the requisite steps and inquiries you would undertake when carrying out due diligence so as to establish the viability of your transactions. Of course, under regulations 2, subregulations 2 of the Advocates Professional Code of Conduct regulations, they state that any lawyer, as an advocate, you have a duty to conduct proper due diligence. So this due diligence must be conducted properly. So after you doing due diligence, then of course we shall bring in the case of Ausi, where they say that land is not like vegetables where you buy from a non-vendors. So that means you have to conduct searches from the registry. You have to also conduct searches on the person selling you land, about his NIN, whether his NIN represents the physical person, because the person can even go and go to NASA Road and then forge his identification card. You find that he puts the photo of someone different. So you have to be able to bring out clearly or identify that kind of fraud. Then after that, you have to also continue and visit the land. Now we have the case of Labeka Musoka, I think, where they are saying that where the lawyer went to the land and saw an old woman, but then continued to transact, and they say that you did not carry out proper due diligence, so that means fraud can be imputed on you. So we shall also meet the doctrine of bona fide purchase of value without notice, which most of us are looked at undergraduate. So, but once you have failed to do proper due diligence, either by implied or constructive notice, that basically means that you cannot rely on that doctrine of bona fide purchase of value without notice, and then fraud will be imputed on you. And once fraud is imputed on you, you know the outcome that under section 59 of the RTA, a certificate of title can be impeached on one of the grounds, which include fraud. So basically that's how you conduct that due diligence. Then the rights of unidentified third parties or parties and other legal factors that substantially affect any attended transaction. So basically here we shall look at spousal consent. You have to get spousal consent from the spouse. We shall also look at joint tenants. You have to get consent from the other tenant. Also the tenants, you have to give them notices when you're going to buy that building. And also we have a lawful occupant or a bona fide. That will be the debate under section 29 of the Land Act. Remember, a bona fide occupant cannot be evicted without compensation, because they enjoy what we call lawful occupancy. Then we shall also look at deed draft any documents you would use at this stage. So in looking at the documents, of course here we shall draft the spousal consent, we shall draft the notice to the tenants, we shall also get consent from where? From the joint tenants. You get from the joint tenants. Basically I think that will be it. So in case you find this discussion enjoyable or fruitful, in the weekend we discuss more than this. Our discussions are very good, they flow, and we make sure that every student understands. For us, we don't assume that anyone knows the law, we teach the law, like what I'm doing here. But in the discussions on Saturdays and Sunday, we go more into details, and even we are proceeding very slowly, not as fast as I do here, because if I'm going to be slow, then it's going to take me like 2 hours pass through this workshop, yet I understand that most of us do not have data. But in case you want to be part of that mastermind group where we discuss all this workshop and then get notes after the discussion, please you can contact me on the number on this YouTube channel, and then I will give you more guidelines, and then you see whether you can be part of that group, because students in that group pay a monthly subscription fee to support our research and also help us get acts and also buy data. So having said that, I hope that you find this very interesting, and please, if you find this interesting, please like, comment, share and subscribe. But let us go to workshop 2 because we must pass the bar course. We want to increase the pass rate. Our mission is to increase pass rate of LDC to 80% from the previous 30%. We want to have 80% students passing the bar course at the first sitting. And I believe that whoever is listening to this video, who has come this far, you're going to be part of that 80% who will be passing LDC on first sitting. Please receive that. Workshop 2. This workshop deals with how these rights in land are acquired, protected, controlled, regulated, and in some cases how they may be lost. By the end of this workshop, you should be able to explain principles relating to acquisition of interest in land, structured transactions relating to acquisition and protection of interest in land, draft various documents for acquisition and protection of interest in land, recognize and deal with issues relating to acquisition and protection of interests in land. So we shall look at the several main authorities, including the Constitution, the RTA, the Land Act, as well as the Contracts Act. Powers of attorney. The locus class case on powers of attorney is Frederick Zabwe versus Orient Bank. Of course, that case discusses powers of attorney. The first time I read it at my undergraduate, it was a very good case. I hope that you also read it. But briefly, if you don't have time, we are saying that, of course, powers of attorney must be very well attested, and once they are not attested, then that means they are not valid. But I think we have section 139 of the LRT which provides for the powers of attorney. We even have a structure of the powers of attorney in the schedule of the LRTA. I think that's schedule 14. Of course, don't bind me on those sections. I'm just getting the sections off head, but I just give you a guide to go and find out where the law is. Of course, a good lawyer is the one who knows where to find the law, and I believe I'm one of those good lawyers, because I really know where to find the law, however much I might not know the appropriate sections. But of course, in our Saturday and Sunday discussions, we are very well researched and also rotated. We don't submit on hearsay. We submit with authority, backed by cases and sections, and we don't doubt anything, because by then we have had what we call thorough research. But here, I just come here to give you a skeleton of where you can begin from your research, because at LDC it can become very hard if you're beginning from zero. You don't know where should I now structure my thinking. You can easily go astray when what they want is just as simple as this. But of course, we're saying about powers of attorney. Then rights of parties, transactions of the sale of land, and of course Katariko versus Katwiremu. They are saying that once you have made a deposit on the land, you have an equitable interest. Therefore, the seller or the vendor is only entitled to full purchase or to full price, and you can only sue for specific performance, which would be to sue the buyer for the remaining balance. So the scenario I can give you to understand this is, if I own a land in Munyonyo, like I will soon do, and I'm just selling it for 1 billion to start a franchise with maybe Coca-Cola, and then I sell you that land at 1 billion and deposit 500 million, and then after that I get a Mzungu who is giving me 10 billions. I cannot sell that land and then come back to you with your 500. No, because once you pay part of the price, you have an equitable interest, and once you have an equitable interest, it basically means that me as the seller, I'm only entitled to the balance, and that's what I can sue for. But of course, I wait for that as we go into the workshop. We shall look at where that can apply. Essence of time. Sharif Osman versus Haj Haruna Marangwa. We know that time is of essence, of course, in contract law, as we shall also look. Powers of an executor or administrator of an estate, of course, Rus Sirimuzao versus Paulo Mukasa. They are saying that, of course, an administrator of an estate is supposed to transfer the property to the beneficiaries. Rights of the beneficiaries, Israel Kabga versus Mountain Banabo. The court is saying that they have the right to sue. They have the right to sue in case their estate is being mismanaged. Beneficiary caveats, of course, we can see that they have the right to lodge a caveat. They have the right to lodge a caveat. We shall have to look at the LRTA on the possible section of where the caveats apply. I think it's either 139 and 123. One is either providing for the powers of attorney, and the other is providing for the caveats. But I think caveats are in 123, if I can remember very well. Then vesting orders, Rwanga versus Registrar of Titles. Once you have paid full purchase price, once you are in the possession of the land, but the seller is missing, you apply for what we call a vesting order. And I hope you have gotten those conditions stated in Robert Mukanza and Petua Mukanza versus Registrar of Titles, also in Ivan Mutaka, that assume that you have bought my land, and I have maybe I had an urgent meeting and I fly to USA and I'm not going to come back, but you're already in possession and you paid full purchase price, so you don't demand you anything. You proceed under the vesting order section, and the registrar will be able to vest that title into your names. Of course, dealing in land owned by minors, the law is very clear and straightforward. You must have a guardianship order under the case of Akuze versus UNRA. And another, you must have a guardianship order. For example, if you get your land and register it in the name of your son, you can't mortgage it in the bank. You will need what we call a guardianship order, and to get a guardianship order, you go to court and proceed by notice of motion supported by an affidavit. Then citizenship and ownership of perpetual interest in land. So basically, I want to look at, of course, the case of Binzika Enterprises versus Binzika Enterprises discusses about what is a company, and that a non-citizen company cannot own land in Uganda except by leasehold. Of course, there's a big discussion on what circumstances a company is said to be a company, but a company will be treated a Ugandan company if Ugandan citizens owns more than 50% of the shares in that company. But in some instances where an Indian has 50 and a Ugandan has 50, the court will look at who makes the majority of decisions. You also have to look at Formula Feeds versus KCB Bank, Uganda Limited. Of course, the court is retaliating that a non-citizen cannot own land by freehold. You can only own land by leasehold. Of course, that one is supported by the Constitution as well as the Land Act. We shall also look at the law governing trusts. Of course, if you want to, you can also create a trust for your land and give it to your beneficiaries. And we have seen Sounder versus Volunteer. It discusses about trust land. So we shall also sit down the Trusting Corporations Act and how you can make a trust for land. So basically, that was the introduction. I hope you got value from it. Let us now proceed to analyze and discuss the workshop. Part A. The factual scenarios in workshop 1 apply the workshop Mutati Mutandas with a few modifications. However, Mr. Goodluck further informs you that he has another piece of land that he does not want to sell. He tells you that he inherited a piece of land measuring 200 hectares located in Chankwanzi district from his father. This piece of land has run in his family for generations and will continue to do so in accordance in their customs. Mr. Goodluck tells you that he wants to obtain a certificate of that land. Advise him on the steps you are likely to take should you accept the instructions and obtain the requisite documents. So basically for this, we are going to apply for what? For certificate of customary ownership under the Land Act. And basically when you look at it, from section 5 up to section 9, they give you the process of how do you get a certificate of customary ownership. How do you get the process of getting a certificate of customary ownership, and where you have to do what, and where you have to apply. So basically that's what we're going to be looking at, and how do we get what we call certificate of customary ownership, and have to look into the Land Act, basically section 5 to section 9, where they give you how do you apply for that. So the documents are also there in the regulations. You will see, of course, you need the application form, I think a survey report, something like that. But when you read the Land Act together with the regulations, they're going to give you these documents. Then part B, Mr. Benson Mgaga is before you. He tells you that he's interested in acquiring the land comprised in folio, if that means freehold. West, Mr. Benson has instructed you, the law firm, to handle the transaction on the behalf. He avails you with a copy of the certificate of title. Upon establishing the transaction in respect of the land comprised in folio V56, which is viable for sale, the parties agreed to the purchase price for the sale, 50 million, and the same to be paid in civil installments. Draft the most appropriate document by which the sale and purchase transaction will be concluded. So basically here we shall draft the sales agreement, of course headed the Republic of Uganda, in the matter of the Land Act, in the matter of the RTA, in the matter of the Contracts Act, then parties. This agreement is dated, this is dated between the parties, consideration, talk about consideration, you talk about terms of payment and all that stuff. Then advise Benson on the steps you would take to enable them to obtain the legal interest in the land. Of course, you have to draft what we call transfer forms. Then after drafting transfer forms, you pay stamp duty. Then also you proceed to register them. So the most important document here would be you draft a transfer form. So transfer forms, I think, have them in the regulations. If you can read the regulations, have the transfer forms. Then duties and fees paid. Of course, you have to pay stamp duty, registration fees, and legal fees. And of course, stamp duty, remember, we have the case saying that failure to pay stamp duty is an illegality. ISCO issues, don't overcharge your clients, make sure to pay appropriate fees, avoid conflict of interest, all those kind of ISCO issues. Part C, Assuming that the parties have roughly entered into the transaction B above, and after paying the first installment, Benson failed to pay the balance of the purchase price. Despite the several reminders, Mr. Goodluck wants to sell the land to another person with capacity to make one payment in full. So this was the principle we talked about. Advise Mr. Goodluck on the remedies you would pursue on his behalf and on the procedure of invoking the remedies. So basically here what we can see is that assuming the parties have roughly entered into the transaction above, after paying the Benson failed to pay the balance of the purchase price despite several reminders, Mr. Goodluck wants to sell the land to another person. So we talked about the equitable interest that once this person sells the land, he only has the land as a lien and is entrusted to the balance. So basically here, Goodluck, what he can do, he can serve a notice of intention to sue and then proceed to court by plaint to sue for specific performance or suing for the breach of contract, which basically is to be paid the remaining balance. And the most important document here would be a plaint for breach of the contract, asking for specific performance to pay the balance. So part D, assuming on the other hand that the Benson fully purchased land comprising freehold volume 56, he paid the first and second installments. However, he was approached by LC1 secretary of the area, who told him that he had been requested by Mr. Goodluck to ask him to find some time and agree with Mr. Goodluck on how to receive the refund of money so far paid. So basically now the seller wants to refund the money. So advise Benson on his interest on the steps he can take to protect the interest. So basically you can see here that Benson has what we call an equitable interest. So that basically means that Benson can do what? Can lodge a caveat on the land to prohibit any other further dealings. So the most pertinent document here would be, of course, you have to also sue. You have to also sue for specific performance. But here now it's the buyer. It's the buyer suing because the other person has done what? Has failed to do what we call specific performance. So now this is a plaint also brought by the what? By the buyer. Then assume that Mr. Benson is in possession of freehold west upon completion of payment of the entire purchase price in the transaction outlined in B above. Unfortunately, Mr. Goodluck passed on without signing any transfers in his favor. Mr. Rose Owensha is in possession of the duplicate certificate title above. So here basically we're looking at whether he can apply for what we call vesting orders. When you look at LRTA, they provide for vesting order. I think it's in section 151 of the LRTA, which basically provides for the law on vesting order. Yeah, section 151 of the LRTA. So you have to look at that. And even the schedule gives you an application for vesting order, how you apply for that. So you have to apply for vesting order so as the land can be vested into his name. So in Rwanga versus Register of Titles, the conditions are one, that you have paid full purchase price, you are in possession, and the seller cannot be found. So you proceed under what we call a vesting order. Part G, assuming a legal assistant to the Deputy Vice Chancellor of Namirembe Archdiocese, Mr. Goodluck has opted to donate his piece of land, where is duly registered, comprising in Chagwe, measuring approximately 10 acres. What steps that you would take to cause Namirembe Archdiocese to obtain a legal interest in the land? So basically here we have to proceed under the Trust and Corporation Act, and we do what we call a trust deed. So once you have this trust deed, you can easily give this land to this one and a trust. Draft the most pertinent document would be a trust deed, and then the fees, of course, we have registration fees of the trust, but also have to look into the Trust and Corporation Act for all these. Then the issues, not overcharging your client, avoiding conflict of interest, and also paying appropriate fees. Then Part H, assume that Brian Musoke applied to the Register of Titles claiming title by possession on land comprised in Port Bahalod. However, Mr. Goodluck Omisha tells you that sometime in 2013, Mr. Brian Musoke was evicted on the land for a period of 7 months. Thereafter, Mr. Brian Musoke forcefully returned and started using the land. The steps that he may take to protect that interest. So basically here you lodge a caveat, against adverse possession, and then you draft the most pertinent document would be a caveat against adverse possession. If you look into the RTA, I think have that caveat against adverse possession. But I think I've jumped some tasks because there is where we are supposed to draft powers of attorney, but I think I did not talk about that. Yes, Part F. But if they are saying that, assume that on the other hand, that Benson Mgaga fully paid for and got registered. He currently lives and works in Kenya. However, he wants to sell off the land at profit, and from the proceeds, he intends to purchase the land comprised in Chandodo. He is so busy and cannot leave Kenya. So basically, here you proceed by powers of attorney, and you give powers of attorney to this person to act for you. So the document here would be the powers of attorney, and I think we have them in the RTA, the structure, and how they should be drafted. So that was it for workshop 2. Let me pass through workshop 3. The facts of part D workshop 2 will be used. By the end of this workshop, you should be able to explain process relating to acquisition of interest in land, structures, transactions, draft various documents, and organize ESCO issues. So I can't advise on workshop 3 because the facts are not adequate. We need more information. So in case you like this discussion, on Saturday at 8 p.m. we always have an in-depth discussion of the workshop, and also after we use the notes, and then after the workshop we release the notes immediately, because already those are the notes we use for discussion. Then also on Sunday 8 p.m. we also need to go into discussion of workshop 2, and then also we release the notes immediately. Of course, we have students from Barara, students from Bari, students from Rida, as well as students from Guru. So if you want to be part of this team, please WhatsApp me on 07075 67 284 075 67 284. That's our contact, and it's also on this YouTube channel app. So please reach up to me, and then you will be part of that team. Members pay a monthly subscription fee of 100,000 each student. 100,000. That's a very good investment in yourself, because after passing the bar, you can even get 100 million in one transaction. So there is no need why you shouldn't invest 100,000 per month to have a person who's going to be your coach, at LDC. Even if you're the best player, like Cristiano Ronaldo, like Lionel Messi, you definitely need a coach, someone who has walked through your journey and can tell you what not to do and what to do. It has been a pleasure as well as a blessing. Please have a blessed day.